recording now. All right, if it sounds good, I'll kick it off. Hello and welcome everyone. Thank you for joining this webinar today. Today's session is brought to you by the Office of Small Business at Prosper Portland in partnership with the Small Business Legal Clinic. You can connect with the office anytime at pdxofficeofsmallbusiness.com or by calling 503-241-4594. And now I'm excited to turn it over to our presenter today, Nate Webb from Focal PLLC, who will share with us some strategies around how entrepreneurs can effectively hire and deploy legal counsel. Thank you, Nate, and please take it away.
Thank you, Dan. Well, hello, everybody. And as Dan said, the webinar for today is how entrepreneurs can effectively hire and deploy legal counsel. My name is Nate Webb. I am the co-managing and co-founding partner of Focal PLLC. We're a 13-lawyer law firm, primarily based in Seattle, but we also have multiple attorneys in the Portland area, and we're super excited to do this presentation for you. I'll go into my background in the firm really quick, and then I'll hand it off for Venkat Balasubramani, who is the co-managing partner and co-founding partner and one of my best friends, who helped me start Focal 16 years ago. About me, I am a licensing and commercial transactions lawyer. I started my career at one of the big firms, Perkins Coie, many years ago. Been practicing for about 25 years. I've also been in-house at a technology company, serving as a VP of corporate development and also a general counsel. And then 16 years ago, Venkat and I wanted to start a law firm that primarily serviced the tech industry, though we're a bit more broader now. And one big issue for us was also creating an environment that had a nice work-life balance, but also stress diversity and inclusion. And so that's one reason why we're really excited to be here in terms of giving back to the community and informing people on how to hire and use us. So I will let Venkat introduce himself, and then we'll kick off.
Hey everyone, thanks very much for inviting us. And as my background is very similar to Nate's, I started at a big firm in Seattle, Washington, Perkins Coie, and for the past 15 years, Nate and I, or 16 years, I should say, Nate and I have been co-managing Focal. And I primarily handle litigation and disputes, and I've handled a range of such disputes ranging from arbitrations to federal court litigation and intellectual property and brand related matters. I think that's enough on my background. Thanks again for having us, and we look forward to participating in this webinar.
All righty, great. Well, hey, I'll just dive right in. And so, as you can imagine, us being running a law firm, we deal with entrepreneurs quite a bit, and especially startup companies, and oftentimes, especially in the Seattle area or in the Pacific Northwest and Portland, new entrepreneurs who have came from maybe larger companies, the Amazons and the Microsofts of the world, and they've decided to venture out and start their own business. And one of the things often they need to do is find legal counsel. And some of them, and frankly, many of them have no experience in terms of engaging, identifying, and using legal counsel. And that's what this webinar will touch on. And I hope it's helpful for all of you. So we'll go right into the PowerPoint. And in terms of the roadmap, we're going to talk about the search, so finding a legal partner that can work with you. We'll also go to the financial aspect in terms of how does an engagement typically look like, so that when you're talking to the lawyers and you're talking about sort of cost and evaluating ROI, you understand how that's set up. And then effective deployment, which is actually really important in terms of making your lawyer a strategic asset. There are some things you can do to maximize your return on investment with respect to the use of legal counsel. And so we'll go into some tools that you should think about and issues you should think about as you're deploying and using an attorney. So phase one, the search, finding your legal partner. So first is the vetting process. Let's just go over that really quick. Trusted referrals. So I think this is really big. One thing I would advise everybody is granted, we don't have the paper yellow pages anymore, thankfully, with the advent of the internet, but I don't necessarily suggest going to the online version of the yellow pages and just sort of saying, oh, that lawyer, yeah, okay, I'll just pick one. I think it's important to be a little bit deliberate as you look to find somebody who can help your business. And I always say the best introductions come from your network. So to the extent, for example, you're on LinkedIn or you're in some trade organizations, or business organizations, talk to entrepreneurs, talk to people in the space, talk to people into your industry, and see who they are using for legal counsel. That is much more effective than randomly choosing a lawyer based on a Google search. So as I note here in the slide, talk to fellow founders, talk to investors, talk to your accountants. But it's really, I would stress that you're gonna maximize your chances of success in terms of having a lawyer that you're gonna feel comfortable with. If, for example, a business colleague of yours says, hey, I've used this attorney, I used this firm, they did a good job for me, they were pragmatic, they were cost effective, that's just gonna increase your chances of having a good experience with your lawyer. So I always say trusted referrals. Interview multiple firms. It's very much like hiring, right? If you for your business, in that you usually are not just talking to one candidate, you're talking to multiple candidates. And so I would look at your lawyers as an extension of your team. And often with businesses, your team is the most important aspect of your business. And so it's important for you to take the time to talk to multiple firms, because they're going to be different. Some will be large firms, some will be small firms, and I'll get into that. Some might be more expensive, some might be more specialized. And so it's really important to talk to multiple firms. You're hiring for a critical role. Consider as many options as you can before making your selection. And I also say this also is just be careful with the stress that might induce you not to do that. And I'm referring to litigation. I think sometimes when companies are faced with scary things, whether that be a subpoena or potential litigation or something like that, they might be quick to jump the gun in terms of, I just got to talk to a litigator now. I need to hire this person. I need to go. And again, I just remind everybody to be deliberate because it could have very big ramifications for your firm or for your company with respect to your cost outlay, whether you're getting service, et cetera, et cetera. Initial consultations. So most firms targeting startups will not charge for initial consultation. If they do, ask why. And I'm being blunt, I'm kind of jaded about the initial consultation fee. I'm not a big fan of it. We don't do it. Many firms don't. And my big issue with it is that it can come off as more of a revenue opportunity for the law firm instead of a sort of a deliberate talk with a potential client to understand what their challenges are and what they need. And all of our time is valuable, including yours, and obviously the cash on hand that you have is really important. And what I worry about with initial consultation fees is, and not to disparage my profession, but where lawyers will just take you in to talk to you to get that $250 for 30 minutes or $500, whether or not they know they can help you or not. I'm not saying that goes on a lot, but I'm just saying I don't think you need to go that route, and I would say avoid it if you can. And if they do charge an initial consultation fee, don't be afraid to ask, or ask them to waive. I think we'll get into this a little bit later, but at the end of the day, you are the one hiring. You are the one writing a check to a service provider. So you have a right to ask questions. You have a right to negotiate. I think that's really important for entrepreneurs. And I think an initial consultation fee is completely on the table with respect to maybe a point that you will push back on. So just be wary of them. That's all I'm saying. And confirm confidentiality. Information you share in a consultation is generally confidential, even if you don't hire the firm. Don't be afraid to seek this insurance. Now, as lawyers, we are bound to the ethical rules of professional responsibility as released from each state that we are licensed to practice in. And so when you tell us things, it's confidential. And I'll just give some anecdote. I'll give you an example of how this comes into play. We have a litigation team. We are a full service firm and that we handle commercial transactions, corporate licensing, privacy, but also litigation. And we get unsolicited reach outs of, hey, I need to sue this person, or someone's going to sue us, a company or an individual. And one thing that has happened from time to time is a potential client will reach out and say, I need to sue Acme Corporation. We do our conflict check to see if we can even handle the matter. And we find out the person they want to sue is our client. And it does happen. Thankfully, not frequently, but it does happen. And we're bound by confidentiality. We cannot, at least in the state of Washington, under our rules, disclose that you reached out to us to sue our client. We're not allowed to share that. And you should seek those assurances from whoever you're talking to make sure, one, that they're familiar with the rules with respect to confidentiality, and obviously to give you the comfort level to be candid. One thing I don't have in here is conflicts. And basically at a very high level, we have an ethical obligation to obviously represent our clients to advance their interests. And to the extent we have interests that might be adverse to our client's interests, then we typically cannot represent the potential client. And so, obviously make sure and confirm that your law firm or the individual attorney that you're speaking with has run a conflict check. Confirm, I assume there are no conflicts. And what we do when we vet potential clients is we ask the potential client to give us a very high level overview of their issue, and then to identify the parties. And then usually takes us about 24 hours. We run a conflict check. We go through our files, we ping all our lawyers and staff and ask, hey, do we represent any clients that might be adverse to this potential client? Or are there any personal issues or other issues that might cause us not to be able to represent this client? So keep that in mind. I typically don't like a potential client to just give me everything under the sun before I speak to them. I want to run that conflict check first because I want to minimize my chance of getting information that could make things complicated with respect to my existing clients to the extent there's a conflict. Venkat, did you have, and Venkat, feel free to chime in anytime.
Will do.
Okay. What to look for? Candor. Prioritize candor over comfort. Hire the attorney who tells you what you need to hear, not just what you want to hear. That's important. I always tell clients, I am not a business owner. Lawyers actually aren't very good business people generally, in my opinion. What I'm here is to help you, the business owner, make an informed decision. I try not to sway clients either way to the extent they're dealing with an issue that has a risk profile. I tell them all sides, the good and the bad, and then the entrepreneur asks questions and then can make an informed decision. And sometimes we'll deal with clients who might be doing something that might be really pushing the edge. And they almost want me to tell them, oh, no, you can do that. And the good lawyers don't do that. They will tell you where the risk lies, what are the consequences, what are the issues, and what are the ramifications. And that's what you should be looking for. So if you sense your lawyer is just like, yeah, do it, Yeah, do it. Oh, we can do that, and we'll bill you X, Y, and Z. Maybe some red flags in that it's like, okay, are you sure? We're really analyzing this issue fully because you, as the business owner, have a right to know everything so you can make the correct decision. Challenge. Question your lawyer's advice. A good lawyer will welcome questions and be able to explain the why behind their recommendations. It's your business. You have a right to understand. I think, sometimes entrepreneurs and business owners can be somewhat intimidated by their lawyers. Don't be. We're normal people. we can make mistakes. I think, finding the lawyer where you feel like you can talk to them and feel comfortable being able to challenge them and to question them, that's really important. If a lawyer is sort of talking at you or talking down at you or generally not being professional or getting defensive, to me, that's a red flag. I personally like to be challenged by clients. I think it makes me a better lawyer. But it also shows that the entrepreneur, business owner, or client is being thoughtful. And at the end of the day, if you have a quality lawyer and a thoughtful client, you're going to get good legal counsel and a good deliverable and a good work product. So don't be afraid to challenge your lawyer. Ask for a summary of past work. Has the attorney handled your issues before? How much experience with the subject matter? That's important. At the end of the day, let's say we're talking about a young lawyer that's new in the industry and just starting out. They're going to have different experience levels than you talking to a corner partner at a large firm that has dealt with an issue repeatedly. And so do not be afraid, let's say, in terms of you're in a certain industry and asking the attorney, have you dealt with this industry before? What issues are unique to this industry? I have a trademark issue. How many trademark registrations have you filed? Have you handled office actions or companies that dispute your trademark application? That's important. I have a lot of confidence in our profession that we're always doing things on the up and up. Regardless of the lawyer jokes and maybe our the general thought among the world about lawyers. But the reality is there are lawyers who will bite off more than they can chew in the interest of getting work. I understand that. And so it's important for you to challenge, to ask for examples, because lawyers aren't cheap. They're expensive. I can't sugarcoat that. And if they are going to be expensive, you want to make sure you're putting your best foot forward and getting the best legal counsel that you can. And you can only get that, or generally, you will increase your chances of getting that if you're asking questions and getting examples of past work and getting to that comfort level of this lawyer has handled my issues. They can speak to me intelligently on it. And also they will be efficient when they do the work. That's really important.
Hey, can I ask a quick follow-up question? This is super helpful, and I don't know if you might cover it later, but I think a lot of times when we work with business owners, we don't know what we don't know. So do you have some maybe sample questions that people could ask that to share some ideas?
Yeah, it's going to be probably subject matter specific, right? In terms of the questions, but I guess us being in the tech industry, for example, and this is actually relevant in this day and age, is AI companies, and so frequently we'll hear, what's your experience with AI? And we might not be able to identify specific clients due to our confidential obligations in terms of not disclosing our clients, but it's perfectly fair to ask, okay, are you dealing with, have you advised companies who are using AI agentic automations, for example? Now notice, I'm being very specific there. But I think really just starting with your business model and then really tying your question to that business model in terms of whether it's the specific service you're offering or the product or the intellectual property, and asking a very pointed question on the firm's experience with that service or product or widget. And then also industry, because certain industries have certain issues. Whether you're in the tech industry, if you're in the food industry, are you in the cannabis industry? It's really important to make sure that the law firm you're dealing with has specific experience in that industry, because many industries are regulated and have very unique issues. And I think cannabis, for example, is a really good example. And if you don't get that experience, you really risk paying for get up to speed time. And that can be very expensive for a client. And I've seen it happen where they feel comfortable with the firm, but the lawyers don't really have experience. And so they're billing the client, though it's debatable in terms of whether that's ethical in terms of sort of learning the subject matter. I hope that answers your question.
Yeah, that's helpful. Thank you.
Okay, great. Firm models, large firms versus boutique firms. So Venkat and I, we've worked at both. And then also myself and Venkat, actually, we both served in-house where we had legal budgets. And so we had to evaluate whether to use large firms or small firms. So really quickly, large law firms, some pros and cons. One, full service, one-stop shop for diverse legal needs. Large firms are going to have tax groups, they're going to have corporate securities groups, they're going to have licensing groups, and it's kind of nice to have that if it's a full-service firm and that you don't have to talk to multiple attorneys. And then almost more importantly is they have familiarity with your business, and that helps with the efficiency with respect to them providing you legal services, in that there is less likelihood of get up to speed time if an entire firm is handling all your issues, whether that's employment, your cap table, your licensing, etc. Large firms typically have extensive resources and a deep bench of specialists, established brands and connections, though this can be overstated. I do want to say that in that, we started Focal, and worked before that when the internet businesses were just exploding, and there was a lot of venture capital, a lot of investment. And one thing the large firms would say would be, well, work with us and we'll introduce you to all the investors. Challenge them on that. I have seen where it's like, yeah, I hired this law firm that's $750 an hour and I thought they would introduce me to all the money people. I didn't get any money. And so just be careful about that. Be a savvy buyer and don't easily fall for that. The cons, significantly higher costs. That is definitely a thing. In Seattle, the large firms are starting to exceed $1,000 an hour, which is incredible. And so keep that in mind. They generally are going to be a bit more expensive. Often risk averse, which can stifle entrepreneurial speed. Large firms will tend to, I don't want to disparage, but if I use the term over lawyer, that might come up as disparaging. But you just got to be careful about that, because they're really worried about risk. Not that we aren't, but I think sometimes the larger firms can tend to sort of not be as pragmatic, especially for smaller companies and smaller entrepreneurs. A lot of times the big firms are used to dealing with companies with unlimited budgets, and that could bleed into how they provide advice to smaller companies. Potential for slow response times, as you may not be their priority client. That's definitely a thing. If Amazon is calling the firm and a sort of a small startup with 5 employees is calling, generally sometimes the smaller company might be kind of pushed down the priority with respect to responsiveness. And the first year associate problem, your work may be handled by junior lawyers. I think that's something you have to watch out for. And it's actually one of those things that you should talk to whoever you're talking to when you're interviewing firms is, who is doing my work? Is it going to be a new associate? Is it going to be a partner? And in some cases, you might want a first-year associate or a junior lawyer working on it because they're going to be more affordable. So keep that in mind when you ask questions to firms with multiple lawyers. Who is going to be working on your matter? Small boutique law firms, more cost-effective and flexible on billing generally, often more agile and responsive, direct access to senior partners with deep specialization. I think that's all self-explanatory, but I just think if you find the right small firm, some of the issues are that I talked about with large firms, like, for example, being pushed down due to the Fortune 100 clients that are calling and things like that. I think you're less likely to deal with that at a smaller firm. And I talk about sort of direct access to senior partners with deep specialization. For example, we have 13 attorneys, and we have, I should know this off the top of my head, 7 partners, and so who have a lot of experience. Whereas at a firm with 1,000 lawyers, maybe there's going to be 200 partners and then a bunch of associates. So just something to think about. Cons: fewer internal resources, may need to refer out for specialized issues. We're generally a full service firm, but for complex tax issues, we'll have to reach out to another firm to assist. So something to think about. Requires more vetting to ensure they have the right experience. I think that's less likely of an issue if you're dealing with a full service large firm. And then a potential for a narrow practice focus that can't scale with all your needs. And that's important. And we've had clients outgrow us, and that's okay. You know, where they start out really small, we help them get to the next step, but we're not going to help them go public or have a $500 million leverage buyout. That's just not us. We don't have the capability or the expertise. And so that is something that you have to think about. Financial, structuring the engagement. The engagement letter is your contract. So assuming conflict's clear, you've asked the right questions, you like the attorneys, you feel like they're being candid with you, you've made the decision in terms of big firm versus small firm, and you want to engage them, and they're ready to counsel you, they will send you an engagement letter per our ethical obligations. And the key areas to check are the scope of work, the rates of the attorneys on your team. And actually, in addition to the rates of the attorneys that they list out, I would also make sure that paralegal costs are also outlined. And in some cases, you might even want to more granular in terms of, are there any sort of other fees like copying fees or storage fees, things like that. And remember earlier in this presentation, I said, ask questions. And this is an opportunity for you to ask questions. Do not just sign the agreement as soon as they send it to you. You definitely don't want to do that. Read it over carefully. Look at the fee schedule. Look at what the rates are for the junior lawyers and the senior lawyers. That might even spur more questions because often the senior lawyers or the partners will be more expensive than the junior lawyers. And so you might make the candid question, can I have a junior lawyer work on this due to cost sensitivities? Out-of-pocket expenses. Is there an approval process? How do they handle reimbursement? And then obviously the termination policies. There should be clear termination policies in terms of how that's communicated, the return of your files, et cetera, et cetera. But again, the general gist of it is make sure that you read it front to back. You definitely don't want any surprises or hidden fees, and you really want to go in with a really transparent and global view of what you're purchasing. Negotiating rates and billing. Don't be afraid to negotiate. And I say that, though it's tough for me as the lawyer, because I'm like, oh, we got a negotiation. How do we handle this? But I want to be candid with all of you. And I want you to put your best foot forward and get your best return on investment. And ask about alternative fee arrangements that align with a startup's budget. And I'll get into that. But it does surprise me sometimes that so many clients don't try to negotiate fees, because I think many lawyers will be flexible on that. So be sure to do that. It's no different than negotiating with a vendor or a supplier or a customer. You should approach lawyers in the same manner. Flat fees, ideal for predictable projects like incorporation, trademark filing, or standard contract review. Many things that come to our desks. We've done it so many times. We know how long it's going to take, and it's not very difficult to say, this is probably going to take us 4 hours and it's going to cost X amount. And I think flat fees is great for clients because it gives you certainty. I think probably the biggest thing that probably annoys the business community with respect to lawyers is the bill and unexpected fees. And oh my gosh, I didn't know it would be that expensive. So ask them. And these type of things, incorporations and trademark filings and copyright filings, those typically can be done on a flat fee. And I would seriously question an attorney if they say they can't do it on a flat fee. Now, for an incorporation, if it's complex, I'm starting a business. I already have investors lined up. It's 10 partners. We have very specific needs with respect to how the company is managed on a day-to-day basis by the board of directors and the shareholders. That might not be able to be done on a flat fee basis, but if it's just you or 2 people, a friend, and you just want a simple LLC or an S corp or C corporation, those type of filings are straightforward. And I encourage you to quiz your lawyer on that and say, hey, how long is this going to take you? Would you mind doing this on a flat fee? It doesn't hurt to ask. And same with the trademark filing. Standard contract review, that can be a little tougher. I think like non-disclosures agreements, things that are very templatized, we've been willing to do those on flat fees. Obviously, if they're more complex agreements with negotiation, which is hard to predict, that's a bit tougher on the flat fee. Deferred billing allows you to defer payment until a specific milestone. Example, closing a round of funding. I've seen that. We've done it. It's a way to sort of preserve your cash. And some firms may be willing to sort of partner with you. For example, let's say you're raising money. It's an angel round or a private placement investment round. And with those type of deals, they tend to get expensive on the legal fee side. You might be able to negotiate with them and say, hey, would you mind taking maybe 50% of the fees? And then I pay you the rest of the 50% of the fees when I close my financing round. Lawyers can be creative. Obviously, entrepreneurs and business owners can be creative. So don't be afraid to ask about creative billing solutions. Equity for fees. Use with extreme caution. It can preserve cash, but don't give away too much of your company early on. This is probably one of the biggest mistakes I've seen in the explosion of the internet, where law firms were frankly sometimes taking advantage of entrepreneurs and tech companies in that they were like, yeah, we'll do your legal work, but you're going to give us 5% of your company. And that is definitely a thing. It still is a thing. Be cautious about that. I have seen times where, a company is wildly successful, and then you think about it and you kind of do the math, and it's like, if they would have paid $20,000 or $10,000 in fees, that's probably better than 5% of their company, and the company turned into a $10 million company. And that has happened. So, and then also another thing I worry about with equity for fees, and we've done it. We have taken equity for fees. But one thing that I also get concerned about is conflicts. Remember, I talked about conflicts. And if your firm has sort of an equity stake, will that influence the advice they give you? It's just something to think about. And again, one of those questions you can ask them if they ask for equity fees. Well, what happens if our ideas on the business differ from yours? That could be a potential conflict if you own part of the company. Understanding the trust account, i.e. the retainer. Your money, a trust account is your money held by the firm to ensure payment. Key questions to ask: is the trust applied to the very first invoice or held until the engagement ends? Or is it an evergreen retainer that must be replenished to a minimum balance after each invoice? So quickly is a lot of times, us as attorneys, we want to minimize our risk in that We want to get paid for our services. And so it is very common for a law firm to ask for security to make sure that we do get paid. And that's the trust account. One, negotiate your trust account. Back to the negotiation part. Just because they say you have to put $10,000 in an account in trust, don't be afraid to say, hey, can we do 5,000? I'm doing a flat fee incorporation for $2,000. That's all I need. Why do you need 10,000? Let's go with 5,000 or 2,500 or what have you. Another thing, and this is also just to reduce the gotcha, is, and we handle trust accounts different ways, but in some cases we'll say, we'll take the trust, we'll do the work, and then we'll apply the trust when the work's done. And we'll just leave it at that. And that's very good for very discrete projects where maybe it's just lasting a couple weeks. They deposit, it's in our account, it's separate from our operating account. It has to be per the ethical rules, at least in Washington. So you should ask that, does that how it works? Because another way it could work is, no, the $5,000 that you put in, or 10,000 or 100,000, it's going to stay in that separate trust account until the entire engagement is closed. So you pay as you go. And that could be a shock to people. And I've seen firms who don't do a very good job of communicating that, where they'll take the trust, and then the client is like, okay, apply my trust to this invoice. And they'll be like, oh, wait, check your engagement letter. We actually keep the trust, you pay. And then if you don't pay, we can use the trust as security. So just make sure you read that fine print, because that I have seen business owners kind of get shocked over that, especially new entrepreneurs or small businesses with limited capital, where $5,000 or $10,000 is a lot of money. And they want that to be applied immediately, not held for 4 years in an interest-bearing account. But typically, at least in Washington, that interest doesn't go to the client. It actually goes to either the state bar, or maybe there's an organization that's entitled to those proceeds of the trust account. So be sure to ask about that. Another thing to remember is, again, I'm licensed in Washington, so I always qualify everything by, as they say, under Washington's rules, but I'm sure it's probably similar in Portland, is your lawyer should not be touching that trust account until you give explicit permission to do so. So, and that's even if you have an outstanding bill. They should be sending you an email or contacting you saying, hey, you have an invoice that hasn't been paid. Can you give us permission to apply your trust? Make sure that's happening. And if it isn't, talk to your attorney about it. We are very careful with that, in that even if the client is past due or anything like that, we will always reach out to the client, ask them to confirm via email, so we have a written record that they consent to us applying the trust account. Very important.
And just to clarify, Venkat, since you're based in Oregon, is it generally kind of similar process in Oregon?
Yes. And it's the general rule in Oregon's no different, is that the funds in what is called a client trust account belong to the client, and the client has to give some sort of affirmative consent to have those transferred, even to pay an invoice, as Nate said. So generally an email or something to that effect is helpful. And I think along those lines, Nate said this earlier, but I think it bears repeating that lawyers are service providers working for you. So don't be afraid to say, ask for an accounting. If you're 90 months into an engagement and there's, a couple of invoices and you're not sure how all this stuff fits together, I think it's perfectly reasonable. And lawyers are subject to heightened rules in this regard. And you, as a client, you can use that to your advantage, which is that anytime it comes to client trust funds or invoicing, lawyers have to be extra careful. And by virtue of that, as the client, you're always well within your rights to say, hey, I wouldn't mind you walking through these invoices and explaining sort of how all this stuff works. And 9 out of 10 lawyers will definitely take the trouble to do so because we're required to do so.
Thank you for clarifying, Venkat. And I'm sorry, but your speaker, your microphone was a little quieter. So when you talk, it's a little quieter. I don't know
Is
if
this a
you...
little better? I can speak up a little bit.
Okay, well, thank you. But thank you for clarifying.
Absolutely.
Yeah, often Venkat and I will joke. There's a magazine up in Washington called Bar News. And in the back of Bar News, it's the list of all the malpractice claims and people who have been disbarred. And we're like, we never want to be back there. And the one thing is when you review it, I would say more than 50% of the disbarments or malpractice claims or things like that are misuse of trust account funds. It is a big issue in the legal community. And so that's why there should be some heightened awareness. Typically, it's lawyers who aren't returning trust accounts. They're using trust accounts for personal use. Again, I don't want to disparage the profession. Vast majority of lawyers are great and honest, but it is a thing with respect to trust accounts not being handled properly. And so that's why I felt like it warranted its own slide for all of you to be careful about it. Effective deployment, making your lawyer a strategic asset. The cardinal rule, don't over-lawyer your business. The legal team is a support function, not the primary driver. Don't let the legal department become the business prevention department. And again, I said this earlier, is my job, and I tell this to clients all the time, is to help you make an informed decision. And I somewhat joked, I don't think lawyers are very good business people. They're good lawyers, but I don't know if they really know generally in terms of how moving quickly and taking risk is often the driver of successful businesses. And the one thing that I see sometimes, and it's sad, and I don't, it's a problem, is young entrepreneurs, new entrepreneurs, and frankly, even experienced entrepreneurs and serial entrepreneurs, they'll sort of get blinded by the big lights of the big law firm and the fancy name and all that. And they're just spending so much money on expensive lawyers, and they're running out of capital for their business. And so it's really important for you to be pragmatic with your capital and your deployment and use of lawyers. You don't necessarily need the $1,000 an hour corner partner at the big firm in Portland or Seattle to do an incorporation for you. Now, many times an associate will do that, but it still could be expensive. But just be pragmatic and make sure that the lawyers aren't making decisions for you or telling you almost consistently, oh, you need to make sure that every amount of risk is eliminated. I would push back on that and say, I just want to know what the risks are, and then I can make a calculated business decision on what I'm comfortable with and what I'm not comfortable with. In my opinion, I've seen a lot of very successful entrepreneurs deal with lawyers that way, and I think it's the most effective way. Spending your seed funding on bulletproof legal documents from a big firm is a waste of your run out of the money for product development and marketing. A client once told me, and this is a true story, once told me they chose a big firm because their papers are locked in a vault. And I was just like, I don't think that's important. If it's on a cloud environment with good security and authentication, I don't think you need your contracts physically in a fireproof safe. And it was funny. He went to this big firm. He told me that. He came back and he says, they were so expensive. I can't believe I fell for their marketing ploys. And then we serviced him, and he's like, oh my God, you're like half the price. Thank you. And I don't care whether my papers are locked in a vault. I just need them to be secure. So just something to think about. This is also really important. is how you communicate with your lawyers. Provide clear instructions in full context. The quality of the legal advice you get is directly proportional to the quality of the information you give. Make sure you're giving as much context as possible with respect to what you're working on, because by doing so, you're going to reduce communication back and forth. And we bill in 6-minute increments. And every email is going to be billed. Some firms are a little bit more relaxed, but a lot of firms aren't. And if they're always sort of pinging you for additional information and finding holes with respect to what you told them, whether that's in a dispute or a contract, that's going to take time. That's going to take back and forth, and that's going to increase your fees. If it's a contract, it's give them the party names, give them how the contract is structured, give them examples. For example, we do a lot of online businesses that might be selling a certain widget. And I always find it helpful. Who are your competitors? Who has done this before? So I can look at their paper, their legal documentation. A lot of times for public companies, you can actually find their legal documentation because it's publicly available through the SEC. If you're giving that full context, you're going to reduce questions and you're more likely to get a deliverable, let's say a contract or a brief, and it's going to be what you want. And so just very much remember that. Set expectations on timing and costs. Align on deadlines and ask for budget estimates on projects to avoid surprise bills. I think budget estimates is sometimes one of the biggest misses for entrepreneurs is they just forget to ask, how much is this going to cost? Always ask that question. And if they can't give you a clear answer on it, try. If someone's experienced and they've done these type of things before, they should have a general idea of how much it's going to cost, how many hours. And then deadlines, that's big. I think it's one of the bad things about our professions is that sometimes lawyers aren't the best communicators, and so it's really important. If you need something in a week, you tell them that, or you ask them, how long is this going to take you? When can I get that back? Because time is money, and maybe you have a big deal, a big customer that you really want to close, and if your lawyer isn't communicating with you on terms of when he or she can get that back to you, that can pose a problem and hurt your business. Distinguish business decisions versus legal risks. I've talked about this a lot. It is the lawyer's job to identify, explain delivery risk. It is your job as an entrepreneur to make the final business decision based on your risk tolerance, and then provide feedback. I love hearing feedback from clients. A good relationship is a two-way street. If you are happy or unhappy with the service, let the attorney know. I always try to solicit feedback. Did it come within your cost expectations? Did you feel like you could be candid with the attorney? Was the advice that you received from the attorney, was it solid? Those are all fair questions, and you should be asking them. I mean, at the end of the day, you're writing the checks. And so if you're writing the checks, you have a right to know how your dollars are spent and making sure that you get ROI. There is one bullet point I don't have on here that I do want to add because I think it's important in this day and age, and that's AI. And using AI to self-lawyer. It's something that I'm seeing a lot more, and it's an issue. And first, we embrace AI, and we even use AI on the operational side. We don't necessarily use AI to let's write a brief or do provide a deliverable. I think that's a lot scarier and it's a lot more problematic. But one thing we're seeing a lot of now, and this kind of happened back in the old days when like LegalZoom came out, which had templatized contracts, right? And then a lot of business owners felt empowered. Oh, I don't need a lawyer. I can just use LegalZoom. And so now we're doing the same thing sort of with AI. And all I can say is be careful. Hallucinations is an issue with AI. And what hallucinations are at a very, very high level is your client, whether that's ChatGPT or some other AI client, is if it doesn't know the answer, it will either make up the answer or it'll draw upon other jurisdictions for wording or language that might not apply to your situation. And it's very convincing. Very convincing. All of us probably have used ChatGPT at some point, and you're like, "Wow, this is an expert." But it's not necessarily. It has a lot of flaws, and so I would just be very careful with it. We receive contracts from clients, and even larger clients, that we can tell were written by AI, and they have numerous mistakes. And so be careful about that, because you do want solid documentation. And if you create a contract that, let's say, relates to who owns the intellectual property created by your employees in the employment agreement, that language has to be very specific. So the business owns it. And if you use an AI to create the employment agreement, it might not have that language that you need. And also another thing for growing businesses, and I say this to clients a lot, to our more mature clients who are trying to get sold or who are trying to raise money, is when you sell or when you're trying to raise money, when the buyer or the investor comes in and looks at their documentation, they're going to see the AI contracts and they're going to catch the problems. And so that usually wises people up. Oh, yeah, you're right. And I don't want that problem. So just be careful with AI. There's all types of tools out there. Another thing is confidentiality too with using AI. You got to be very careful with that because a lot of time the things that you're providing to an AI client isn't confidential, and it's used for LLM training. And let's say you have a customer and it's a very sort of confidential type business arrangement. Maybe there's trade secrets involved. Trade secrets generally being information that has value by not being known. You could be violating trade secret laws by going to ChatGPT on a non-enterprise account and saying, "Hey, can you write me a contract for this specific trade secret that I want to license out?" You might have inadvertently disclosed it to the world. So just be careful about that. Well, I really appreciate everybody's time in terms of watching this. I don't know if anybody will have any questions, and I know this will be on YouTube, but I encourage anyone to reach out to myself or Venkat Balasubramanian. At the end of the day, we just love helping entrepreneurs, and frankly, entrepreneurs who are people of color, women, indigenous communities. We're very much all about that, and I just love talking to young entrepreneurs. So feel free to reach out if you have any questions. So Dan, that's it. I hope that was helpful. And I don't know if you have any questions, or Venkat, if you had anything to add.
Thank you. Let me stop the recording first.